Okay, so welcome to the Sounds of the Baskerville, but as a video presentation. So today I'm James Flaherty, and I'm lucky to have the star of the show, usually heard on Spotify and iTunes, Chris Baskerville. Good to see you, Chris. How are you?
Good morning, James. Good to see you spent a bit of dollars today.
Nothing but for you, but also for our special guest, Ginette Muller. Good to see you, Ginette.
Hi, James. Hi, Chris. Lovely to see you.
So by way of introductions, for those who haven't seen us before, Chris Baskerville, managing partner of Jersh Sutherland in Brisbane, and also a member of the Insolve panel, and also Ginette Muller, who is principal of GM Advisory, and also a member of thesolvers.com.au. And prior to the program, Chris, you were saying, well, kind of what's the difference between the Solvers and Insolve? So I think just by way of introduction, if you've got a business that's got a bit of a problem, or you're something, like cash flow, or there's an issue you can't solve, you go to thesolvers.com.au. Things are a little bit more dicey, or you need some real help with solvency advice, or maybe it's time to think about closing up shop. Where do you get independent solvency or insolvency advice? Well, that's what you go to Insolve for. The guys and the team at Insolve, or the insolvency practitioners, can give you advice. Now, why would we do that? How many times have both of you seen people looking at Dr. Google in the middle of the night and coming up with just some very bad advice or bad ideas? So Chris, have you come across in your travels anyone who's ever got some really crazy ideas about how to solve a business problem?
Yeah, it's a bit like saying, hey, I've got a headache, so I'm going to go to Dr. Google. It tells me I should cut my foot off.
Yeah, right.
And it's similar in business advisory. It's like, I've got a cash flow problem. Oh, let's reconstruct your balance sheet. Really? It's a similar issue. But one thing I like about the Insolve panel is it's a panel of individual practitioners, all separate, all qualified, all effectively kind of competing out there in the marketplace. Yeah. But we have one common purpose, which is we need the directors out there to get proper advice so that they're not taken by sharks.
Yeah, and the sharks are out there. So, Ginette, we've talked in various forums before about the untrustworthy advisors that float out there in the world and give bad advice. So the solvers.com.au and what you do at GM Advisory is more about trying to get good advice from business consultants you can trust.
That's 100% correct. So the way I see solvers is that you can't actually yourself pinpoint what you need. You know, there's a lot of different products, you know, there's a lot of different advice out there, but how do you know which one's suitable to your particular problem? You don't walk into a GP and say, hey, I've got this. You can tell them your symptoms, but we leave that diagnosis up to medical professionals, and it's no different in business advisory. It's the same thing. Tell us your symptoms. Let us tell you what your options are. Let us try to diagnose the problem for you. By all means, at the end of the day, it's the client's decision on how they progress with the advice, but they don't know what they don't know. And so in many circumstances, it's better to hear from the professionals on the Solvers panel as to what options might be available for your particular dilemma.
And that's a really, really good point. We were all at a conference not so long ago where an eminent person said that if all you've got is a hammer, every problem looks like a nail. So in this particular case, half the time, a lot of the people who would approach us don't necessarily know what the underlying issue is.
I've had that experience many times where a director will come and sit down and they'll tell you what they think the problem is. Yeah. And through your humble diagnosis, you're like, no, I don't think that's the problem. I think what your real problem is something over here, you know, and I think that's what directors need to hear is, hey, I think this is the issue, but we're actually saying, no, it's not. It's actually, and how many times do you get that kind of diagnosis from your doctor? You know, you think you got a shoulder injury, but you've actually got a hip out of alignment. You know, something weird like that.
Yeah, or a chiropractor, something like that. You're bent out of shape, and that's sometimes the job that both of you would have is to tell them some truth that they may not necessarily want to hear, which is sometimes that there's some problems that can't be solved, or sometimes the solutions are going to hurt.
Sure. I think going back to that point that Chris made, the other issue is they might come to you with, I think I need a voluntary administration or I think I need a liquidation. Well, really? Have you heard of a small business restructuring? Have you heard of Safe Harbour? Have you heard of these other things? So in many instances, they may have done a little bit of Dr. Google research, don't know the full facts, need to have a whole sort of buffet of options presented to them. And, that way we can make wise decisions using trusted advisors. I think that's, if there was a key message, that would be what I'd like to see people taking notice of.
It reminds me of a quote we often say to people is you'd rather be slapped across the face with the truth than kissed with a lie. So I guess in one way you could say we're good face slappers.
Because we do it from a place of love.
We do it from love, care, and we're unemotive.
So that's an interesting point that you raised then, Ginette. So a lot of those terms you've used there, a bunch of people would know vaguely about some of them or might have read what they've read on Dr. Google. So we've got, historically, we've had things like liquidation, we've had voluntary administrations and receiverships and all this sorts of thing. And we've got lots of content on the solvers.com.au and also Insolve, and obviously your own sites about what each of those means. But about 2 years ago, something was introduced that we almost thought was the thought bubble at the time, this kind of thing called a small business reconstruction. And perhaps if I could throw to you, Chris, to start, like, what did we think that was and what do you see that they are now?
It's a mini version of what we famously understand to be a voluntary administration with a deed of company arrangement. But it's designed for small business, specifically businesses with less than $1 million of debt. And the idea behind it is to give a very fast resolution to the company and its debt burden, keeps the director in control of the entire business. The directors have to make good employee entitlements to qualify and have debts less than $1 million. But it allows them to say to their creditors, hey, we got stuck through the pandemic. We ended up incurring a lot of debt, but we've got a viable business. The business is starting to show profits and good cash flow. We're just weighed down by this legacy problem. So please give us a compromise today so that we can live tomorrow.
And on paper, that sounds really great. That sounds really good. How many organisations, I suppose, Ginette, have you seen? Because you've been working on a few of these. How many organisations are ready to go straight into small business reconstruction and meet all the criteria?
Look, some of them might need a helping hand to get there. So, you wouldn't see me today, for example, and expect to be able to be put into small business restructuring tomorrow. That's the piece that I help people out with. It's to get them match ready, match fit, if you want to put it in sporting terms. So it might take them a little while to make sure that they've lodged all their BASs and their other lodgements with the ATO, for example, and they might need to, I would say, get ready and have a plan in mind, and then once that's together, we might then wheel them in and see someone like Chris, who would be their small business reconstruction practitioner, who then has control of notifying creditors and sending documents out, et cetera, et cetera. But look, to date, there's been about 143 of these appointments that have occurred. Success rate's very good, particularly when you compare it to any other form of formal restructuring. I think it's as high as 70%, which is amazing. 70% of people who go into SBR actually succeed with their plan. So that gives you an indication that the tax office is pretty much the major creditor in Australia and that they're supportive of that. And I think that, if you look at any of the statements that the tax office has made, they've said, we see this as a fork in the road for a lot of businesses. A fork in the road, make a choice. If you think you have a viable business and it can go on, this is the time to make that decision. And you can exit gracefully on the one door. That might be liquidation or some other form. Or, you might want to give the small business restructuring a crack. Bearing in mind that, you can only do one of these every 7 years, so it's not going to be abused, one wouldn't have thought. You can't be doing this every year. But, I think it's a pretty good offering from the government to enable businesses to have this access to a new tool effectively.
when the government looked at all the data of failed companies, they said, well, one is most of them are small businesses owing debts less than $1 million. So that's kind of what curtailed that. But also small business in Australia employs more people than any other sort of category that's out there. So they needed a mechanism to save the people that employ the most amount of people in Australia. And that's what they came up with. And it's very similar. Most people would sort of have heard the concept of Chapter 11 bankruptcy, which is an American term under the American code. But the similar concept has been deployed here, which is you keep the director in control of the business. And our job is to actually, we become an agent to help the director put these proposals together. And as long as we're trading and as long as we're maintaining employment, and like what Ginette said, all our tax lodgements are up to date and tickety-boo, you've got a chance.
Both of you must love that, but especially you, Chris, who's actively also a liquidator by trade and a bankruptcy trustee, but to stand behind the directors and actually steer them towards a potential success, that's awesome.
Personally, that is what makes me feel good, is being able to actually help a business and keep it alive. Because no one really cares about the 10,000 insolvencies we've done, which ended up in $0 return, but they do care about a business that was able to stay alive because of the part you played.
Okay, so that sounds awesome. You've got the opportunity to really help a small business at a time that, let's face it, we've all been through the ringer with the whole COVID thing. Some people had some of the best business times they've ever had, and yet so many of us haven't. And then we've also heard stories of you've been hit by COVID lockdowns and that sort of stuff. But then, Ginette, you and I have both encountered businesses where now they can't get enough staff to be able to dig themselves cash flow wise out of the hole. So, they haven't got enough people or spare hands to be able to generate enough cash flow to get over those old COVID sort of debts. So, righto. So, sounds good. So maybe let's just go under the bonnet. Let's get a bit of a look into what a small business reconstruction is. And I think the point that is really important is you sort of got to be ready for it first. So perhaps if I could get you to maybe start us, Ginette, off with kind of what people see, what you see with people when they come in.
Sure.
And then we might sort of pass it over there, maybe Chris, to sort of then what happens with when your team come in to be the small business reconstruction practitioner and the hat that you wear, and take us on that little step all the way through. So can we kick off with you, Ginette?
Yeah.
What are you seeing that's coming in the door?
Okay, so we've spoken about this pre-appointment phase, if you'd like to call it that, and that's where I basically meet the client, understand their problems, and then assess them for eligibility. And if they're not eligible at that particular moment, well, what are the steps and what are the processes that we can do to make them eligible? So, it's quite specific what the eligibility criteria is, and that would include, the $1 million worth of debt. You can't have more than that, your lodgements, etc. But there are also other things that we need to look at. Have you made any creditor-defeating dispositions over the last 12 months, for example? Have you given away assets? Are there any things that, a liquidator would find unacceptable? So those types of transactions require a bit of time to talk to the client about and make sure.
Sorry, just as a jump into a creditor-defeating disposition, is that passing off some cash so the people you owe the money can't get it? Is that what a creditor-defeating
Well, that's right. So there may have been a time in the prior to you meeting me where you were insolvent, and so if you were insolvent, if it's deemed that you were insolvent at any time prior to that, then any transaction that you've entered into that may have given someone else an advantage could potentially be clawed back by a liquidator. We call them voidable transactions. A defence or a shield, I'll call it, is safe harbour, which is, that's also something that I might talk to a client about at that pre-appointment meeting. They might not be ready immediately to go into small business restructuring. Like I said, there's some, different match fitness that we need to put them through. But, whilst we're doing that, they might be a suitable candidate for safe harbour, so that at least the trading that they're doing at that point in time, they're not going to be liable for insolvent trading. So there's all these different things that we need to look at and angles we need to look at.
Question without notice then. How many people have you seen who've come to you and said, who meet all the criteria off the bat, ready to go into small business reconstruction?
Probably zero.
That's right.
To be quite
there's
honest.
a bit of work to be done
There is.
to, as you say, get the match fit, help the directors get a bit, start getting the house in order a bit to, because isn't it partly, and you can guide me here, but isn't this partly about demonstrating to your creditors that you've got a business that's viable?
Well, there's that, of course. But also, sometimes people think that it's more important to have paid liabilities, for example, to the tax office, than it is to actually have lodged the outstanding BAS. And that's just simply not the case. Don't be late with those documents. That's compliance in this day and age is what it's all about. Tell the tax office what you owe them. Get those lodgements in, and deal with the liability in due course. Come and see someone like myself or Chris.
Yes. Substantial taxation compliance, what Ginette was saying, is not necessarily paying your taxes, it's lodging your forms. So because the ATO can't make a decision to compromise their position without actually knowing what is their true position. So tell them what the position is. And substantial taxation compliance is one of the key criteria for why you might be eligible for small business restructuring.
So don't hide and fess up is basically what you're saying?
Yeah, I say report your sins even if you can't pay for them.
Okay, so you've got a situation where, we've got an organisation that's had some problems and, we're seeing debts of all sorts of shapes and sizes, I imagine, up to $1 million. Many firms, do you see many firms with that sort of amount of money coming through? Up to $1 million?
Yeah, some are kind of scarily or hairily right on that borderline too, and it could literally come down to whether a creditor charges interest or not, and that could be the deciding factor.
Right.
So you definitely don't want to run it right to the $999,999.99, but you need a buffer there.
So in our Sounds of the Baskerville podcast, we often say, resist the Australian temptation to just kick the can down the road and hope the problem will go away. Here's a new tool that you could use to actually deal with the problem now. And even if you can't pay the tax man, at least if the tax people know what you owe, gets you into this kind of beginnings of this process. Is that what we're talking about?
That's right. And then what we're talking about is a compromise of debt.
Yeah.
So once we know what the liabilities are, we then do a plan, and then we can compromise that if the creditors agree.
So when does that happen? So what happens next?
So when I might have a client match fit, so we've got everything, we've basically thought about our plan. I've looked at PPSRs because that can throw a spanner in the works. I want to know who's got charges over the company. I want to know what are the leases, etc., etc. We've got all of that mapped out. I would then hand that over to Chris and say, this is what I think the plan's going to be. It might not. Chris might find something in the bowels of the beast that make it unpalatable for what the client might have wanted. But from that point forward, really, the client's Chris's. It's up to Chris to then map the path for that individual company.
And once appointed, we've got 20 business days to to help the director formulate the plan, which is like, here's the position that we're in, here's the creditor pool that we're looking at, and this is the amount of money we're going to come up with, and it can't be any longer than 3 years to put this restructuring plan together. And our job is to help them put that plan together, map it out in a report that goes to all their creditors, explain what the return is likely to be and by when, and send it out for creditors to approve. And
I did a presentation not so long ago on small business reconstruction to a bunch of business owners, and the first question that came up was that, geez, 20 days doesn't sound like a lot of time to get all that together. So you've got a fair bit of work to do in a fairly compressed amount of time.
Well, that's why you need to be match fit before that button gets pushed, because 20 business days isn't a long time. And Ginette and I have had experiences where you're a voluntary administrator and you're trading a business in that 20 business days, and you've got to get a report out and you've got to get a proposal. I mean, that is just an insane amount of work. It's obviously what we signed up for, so we do it. But it is 20 business days doesn't go that isn't a very short period of time.
Yeah, it doesn't. And then so what happened? Okay, you fired it out and said, here it is. What happens next?
Then creditors have 15 business days to consider whether they want to accept it or reject it or not participate. And And if you get the majority in value of creditors voting for the restructuring plan, it gets accepted. But yeah, it's a 15 business day window. And what we usually find with that 15 business day window, it gives creditors an opportunity to then come to us and say, hey, look, could you just give us a bit more information on the balance sheets over a period of time or the profit and losses over a period of time? Can you just help us understand it before we cast our vote? Now, people can vote as many times as they want in that. In other words, you can go yes, no, no, yes, yes, no, no, yes. And whatever the last vote cast by the deadline, that's the one that's in.
That sounds awesome. Actually, It sounds reasonably terrifying. But
yeah.
So is it a bit like a sort of mad rush, and then there's this sort of, you're sitting in a room with a clock going...
It can be a bit like that. And I think this is what's interesting about small business restructuring from the practitioner perspective is that we're not trading the business during that whole period of time. It's the director trading the business. And as long as they're conducting business in the ordinary course of business, I don't have to get involved. The only time I do get involved is if they're doing a transaction outside of the ordinary course, and then they need our consent to do that. So, but yeah, basically the pressure's off us. The directors are still in control.
They're still running the business and
still running
in
the
the
business.
ordinary course of business, in
Correct.
a sense. Okay. And do you find that people still kind of phone a friend sometimes during that sort of situation, Ginette?
Sure. I mean, my clients will ask me from time to time, oh, is this all right? Can I sell this or can I buy this? And I'll say, well, is that in the ordinary course of business? If it's not, if it's like selling a vehicle, for example, go and get consent from the small business restructuring practitioner. Justify the decision, and I'm sure it's right. Tell them what you're going to do with the cash. Make sure the PPSRs are followed, etc., etc. It will probably be okay. But you can't give a blanket. This is what's going to happen. Things happen. We have to be flexible. We have to face each crisis or each separate scenario as it appears. Of course,
if the books and records are pretty sharp, all your creditors are accurately recorded. But what can happen, throw some spanner in the works as an example, is say work cover as an example, you have to forecast what you think your wages are going to be for the year. And if it goes in over or under, well, there's an adjustment there to work cover. Now, that could be a higher liability than anticipated, or you could be in a refund position. And sometimes you just don't know what that position is until you get started in the process.
So things kind of come out in the wash.
You need a buffer. That's why I'm saying don't drive this thing to the $999,000 mark. You need a buffer just in case.
Because if you go over, then you're disqualified, aren't you?
You don't qualify, and then a declaration is made at the first 20 business days. Our job is to say, does this thing qualify, yes or no? And so if that first 20 business days we go, no, clearly the debts are $2 million, not $1 million and below, we make a declaration doesn't qualify, and that's it. It's all over.
Can the debts be reduced in that 20-day period, or is it too late?
Things like related party loans, you see that on the balance sheet quite often, which is a director supports the business. It's recorded by way of a loan owed. Technically, the director is a creditor of the company.
Gotcha. Okay.
It is an admissible debt, but a director wants the restructuring plan to get up for the benefit of every other creditor. They can forgive that loan or forgo it or forbear it and just go, I don't want anything out of the restructuring. I'm going to take myself out of the creditor pool, share the money with everybody else.
And that would be a good message to creditors, wouldn't it, Ginette?
Certainly would. Serves two purposes. One, I'm behind this. I'm giving it everything I've got. And secondly, if you're getting close to that buffer, it neuters it essentially. Takes you right well below if that's your circumstances. That's we're all assuming that directors are creditors of the company. Yeah. If you're a debtor of the company, now that's a different story. That might be a bit of a harder sell. So again, in that pre-appointment phase, if you were my client and you owed the company money, I'd probably be having a conversation with you about how we might be able to rectify that situation, because you owe the company money. I don't think that's going to go down particularly well with your other creditors who are sort of looking at you and going, how come you owe this company money and I'm owed money by the company? Why don't you just pay your debts? And that way I can get paid.
More of mine. Yeah, that's right,
so, there's longer conversations involved in that scenario.
And I mean, as I say, you'd see all manner of things come across your kind of desk, I imagine, Ginette.
Sure. Look, you're trying to set people up in a situation for success. So you're finding all of the issues in their particular scenario. that are going to sort of make them fail. And you want to remove those as best you possibly can. Remove all of the hurdles to give them a good run at getting this over the line and having a successful business in the future. And that's what the legislation is ultimately all about. And if this fails, I know maybe you were going to ask that, James, but if this does fail, what happens then? Well, Chris's job finishes. That's the end. And the client then just resumes life as it had beforehand. So it's now got to make some serious decisions about where to next. Can I recapitalise the business? Should I liquidate? Maybe voluntary administration because there was someone who absolutely hated me, voted against it, and if that person didn't, all of these types of scenarios could be present in this particular set of facts and circumstances. And, that's when I come back into the role again. So I'm sort of somewhat absent in the middle. But then if there's failure, I'm back there again to help the client. All right, let's try and work this out now. Where's our plan B?
That's great. So, but I suppose just to sort of step back. So we've got the quiet ticking of the clock for the 15 days. It gets up. What happens? Because that's most of your experience, Chris. So it gets up.
Absolutely. Yeah. No, if it gets up, our job is to hold the company accountable to making sure they make good the plan. And which is usually calling in the money that they promised or calling in the value of the assets that they promised, pooling those monies and then getting those monies out to creditors. And what's really, really cool, a lot of transparency, particularly with respect to practitioners' remuneration, which is always a tricky and a sticky point sometimes with some directors, is we have to fix a fee up front. So we have to say, here is our fixed fee up front to get us in the door to help you through this process. The second part of our fee is a percentage of the fund that goes into creditors' hands. So in other words, if we get a 90, let's just say our fees are 10% of the fund going out. If we get $90,000 out to creditors, we take $9,000 commensurate remuneration. And it has to be commensurate with how much money actually lands in creditors' hands. And I like that.
It's sort of kind of performance related. Also, you're still working on the project. Obviously, as you say too, it may not be a lump sum. Hey, it might be like a paid
monthly
payments.
Yeah, and it's really customizable. That's probably a good thing to make a mention of. It's up to the director to say, well, conveniently, how can you make this fund work and your timing of funds? Yeah.
And then you talk with the creditors to say, well, try and see if you can get something that'll work for everybody.
Well, that's the interesting thing about this particular process. Ginette and I would remember when you do a formal adjudication process in a VA or a liquidation and all that, it's a time-consuming process, lots of formalities to it, court involvement if necessary. In this scenario, if the books and records are really, really good, we'll say to creditors, here is your claim in the company the way we understand it. You've got 5 business days to dispute it. And if you don't take any action in that 5 business days, you're deemed to be admitted for that amount. So, wow, how much does that cut out of the administration side? Brilliant.
And it sounds like it's designed for kind of where a lot of the employers are, sort of small workforce, mum and dad type businesses, all the way through to a few people running a business together. So you're not talking about the top end of town in a lot of cases who've got the money for the big law firms and the accountants to do a lot of the work. So we're talking about something that, as you said, is kind of fit for purpose by the sound. It sort of talks to the sort of people in the engine room of the economy, the smaller parts of the...
I suppose compared to what we're used to.
Is that what you mean?
We're used to quite a lot of formalities in our normal restructuring, anything that comes out of the Corporations Act, which is where this resides, the legislation for it. It's a lot less, structured, I suppose. The mere fact that the directors maintain control of the entity, that they continue to trade, that at the end of it they're not forced into liquidation. They still have control to decide what to do at that fork, if we want to call it something. It just seems a lot more flexible and probably fit for purpose, which was the intention, fit for the purpose of the majority of small businesses in Australia.
So if they say yes, they continue on, you manage the process. If it's no, there are still options to consider. The door is not instantly closed the second that it's a no. It's
not instantly closed, but you have signed, some 7 weeks earlier, if we assume a stock standard small business restructuring process, which has a 4 weeks before you must submit your plan, and then 3 weeks after that for the voting, then, back at day one, you did admit that you were insolvent. So you've now admitted that you're insolvent. What are you going to do?
Yeah. So I suppose that's it's not an excuse to then revert back to Australian type. And
nothing to see here.
Yeah.
We found our small business restructuring. Nothing to see here.
Yeah. So, okay. So, and there's a bit of a point that you've made too, Chris, and this is probably perhaps where Ginette and some of the solvers and others might come back in, is that, okay, I've got to actually work to the plan. So, what am I going to do differently after I've got through this process, and what are the resources I'm going to use as a business person to make sure I'm not back in the same hole 18 months?
Yeah, that's right. Well, viability of the business is a key part. Like, let's just take the thinking of the ATO sometimes. One of their philosophies is this business viable? Generally, we've got to show like a hockey stick recovery, but for, say, the pandemic or but for the floods in Australia, we would have had a gun business. So you want to show that hockey stick recovery. And some directors, the smart guys do rethink how they operate their business and reshape it to be a bit better.
So is that what you'd like directors to be doing, is like, how do I protect myself afterwards? Like, what's the future
well
look
certainly.
like?
And I mean, they have to do a cash flow in any event. So if they can't do one, they need to be engaging someone who can do that for them. They need to be sitting down. They need to be regularly reviewing that. So they need to have good future governance, I suppose you'd call it that. Now, if you don't have that internally, go and see someone. We've got people on the Solvers panel who can assist them in that regard. You need to keep this business viable. It's a shot in the arm. It's a once only sort of gig, once every 7 years, and it's designed to give you a second chop of the cherry, whatever you call it. So make the most of it. Essentially, don't waste it.
Okay, now I'm an accountant, and I go, hang on, these two professionals, that's great, but if I give you that client, what's my job? Like, are you going to judge me because my client's going under, or am I ever going to see that client again? I mean, from an accountant's perspective, wouldn't it be good to work with you? Or?
You work hand in hand. Like, as an example, we had an engineering firm, and it was his accountant that reached out and said, hey, we need help with this client. Fairly substantial taxation debts, because during the pandemic, the guy's income drops to zero, but he's still paying wages at top-notch rates. And he said, what do we need to do? And I said, well, one thing you can do, your key area is get the taxation lodgements done, squared away. I need you to also do a forecast cash flow for, say, 12 months to show the creditors that the business is viable moving forward. Absolutely, you work hand in glove with the accountant, and I like that.
Yes, look, I think that one thing I'm learning, the more of these small businesses reconstructions that I do, is how tax intensive it is in so many ways. So the tax office will expect you to lodge the last tax return, even though they're not due for another 9 months. There's a lot of pressure on the company and the directors and their accountants. You have to lodge that tax return earlier than you would have anticipated, because again, the tax office wants to make sure that if there's a liability arising from that annual tax return, which I haven't seen one yet, that they can add that to the liabilities. It's all about compliance. They then want you to make sure you've done the last BAS. So, if you sign up on the 1st of September, for example, they want the BASs done up till July. They want all of the PAYG done, et cetera, et cetera. So it's a big job for the accountants in actual fact.
It's a bit of a boot camp for directors, accountants, and their advisors to get things ready and then to run through the process. That sounds like a fascinating opportunity, and you say good success rates so far.
Very good success rates, which is indicative of the tax office being on board with this process.
They have been outstanding in dealing with small business restructuring. They know their position. They tell us the way they view the world. They even give us a bit of insight as to what the plan should really look like in order to get their kind of tick of approval. And they're communicating with us openly and freely, which is great. And it feels like that we're working together to solve this problem, which is outstanding.
Brilliant. So, Chris, one of the great things about the profession that you're in and also the world in which you live, Ginette, there's all these words that, and all these, things that sort of you all say, which not all of us necessarily know. Just what again is insolvent trading?
Yeah, well, it's effectively trading a company at a moment in time where you can't pay your existing bills on time, but you're continuing to incur more debt. Insolvent trading claim is where the directors become personally liable for every dollar of debt incurred after the company first became insolvent.
And they may not necessarily know when that is.
They may not know when it is, and usually it's usually a judge that has to determine the date of insolvency, and then you add up every debt beyond that date. That's a personal liability a director owes back to the company.
Yeah, okay, so you say, okay, well, you say it was July, I say, well, I don't agree with that. I think it's later than that. So how can I defend myself against you kind of going, well...
Solvency is an interesting test, and it's kind of like experts at 20 paces.
Right.
I get an expert report done that says insolvency was January. You get an expert report that says no, it was July, and then it's a battle of the experts in a courtroom. And ultimately, the judge has to then sit there and go, "Well, I'm going to have to make a call here. So how about we split the difference, make it March?"
Okay, but I cop that I'm going to get a little bit of a hit here. Is there anything I can say in my defence in this situation? Like, what can I...
Yeah, there are a number of defences. Illness is usually one, which is, hey, for the last 12 months, I was completely bedridden in a hospital and someone else was managing the corporation for me. But I think the one that most directors, if they're prudent and proactive, probably want to consider safe harbour as one of their defences.
And that's kind of where you come in.
Sure.
Ginette, as a safe harbour expert.
Look, I would say... yes, we think of safe harbour as a defence, but in actual fact it's a shield. Same to people not in the industry, I guess. But what safe harbour is it doesn't even allow the whole issue of insolvent trading to be raised. If you can prove you have the elements necessary to prove that you were in safe harbour. I mean, no one wants to go through this process that you were just discussing of the experts at 20 paces. So what we're trying to do is avoid ever having to go there by convincing the liquidator that I was in safe harbour. And therefore, if I'm in safe harbour, what the law says is, well, there is no such thing as insolvent trading. For any director who can prove that they were in safe harbour, insolvent trading is a nullity. So what is safe harbour then, I suppose, is the obvious question. Well, safe harbour is a little bit like it requires the elements that we've discussed with the small business restructuring. So you need to have paid all your employee entitlements. You need to have been a good taxpayer in the sense that you've lodged your outstanding lodgements. Don't have to pay them. You can have liabilities all over the show. In fact, you probably will, because you've also got to suspect that you're insolvent or about to become insolvent to, take advantage of the safe harbour provisions. And most importantly, though, you need to have a better outcome plan. So you need to formulate a plan that basically says, well, I'm at this situation here, I want to get to here, and all of these things have happened, and I just don't know whether I'm going to make it to here, but I'm going to give it a go. And while I'm taking that risk and while I'm controlling the company, I want to be sure that my decisions are not going to be questions down the track and they're going to accuse me of insolvent trading. Because I might be insolvent trading. And so therefore I want to have this defence or this shield against that allegation, just in case my company does hit the wall 6 months, 12 months, 2 years down the track and we end up in liquidation. Of course, insolvent trading only ever matters if we end up in liquidation. So the best way to avoid being accused of insolvent trading or being liable for insolvent trading, don't go into liquidation. That's the first one. And secondly, if you think that there's a possibility of that happening, get yourself some protection, safe harbour protection.
And you might say too that just we're talking before about small business reconstruction. Safe harbour might be an option for some enterprises as they approach that small business reconstruction.
That's correct. So let's say there was 2-3 months prior to you being able to go into small business restructuring. You might want to put in place safe harbour in the first instance. So, I've told you already all of the eligibility criteria for safe harbour, and it's very similar to small business restructuring, except for the fact that you need a appropriately qualified entity, someone like myself, for example, guiding you through that process and making sure that you're aware of what your director's duties are. So the other thing is you're not allowed to breach any director's duties. And, you can find those under Section 180 to 184, as well as insolvent trading. So, you've got to be doing all of those things, and you get to this point, you put your company into small business restructuring, you pretty much admitted that the company's insolvent. So you're buying yourself some protection for those last couple of months is why you might go into safe harbour. Because if your plan fails, we've spoken about this before, you might end up in liquidation. Then you do have a problem, right? Then a liquidator will come back and say, hey, I think you were insolvent trading at some point. Hopefully you don't have to go through that expert at 20 paces.
And a couple of things just spring to mind to wrap that up, I suppose, is that you can't sit there and go, oh, I'm in safe harbour, safe harbour, safe harbour, sort of Monty Python sort of style, can you? You've got to be someone, someone who's...
Good luck with it, because, there'll be liquidators who'll be assessing your safe harbour or your interpretation of safe harbour and saying, yeah, that's not safe harbour.
There's no public database or notification that says I'm in safe harbour. It's actually something, done in secret that's away from everybody else. And it's only when a liquidator comes chasing a director for insolvent trading that we go, ha, surprise, there's the safe harbour plan.
and that's a really good point too, is it's not, you don't advertise that you're...
No.
So the thing about this, and I think the thing about what we've discussed today, is that you need to get advice from people who are qualified and have experience. So trustworthy advisors. So part of what we've been doing in the solvers.com and we've been doing at with Insolve is, if you are in the middle of the night looking for information on those sorts of places, go to places where you can get advice that is, from experienced people who know what they're talking about. There are a lot of untrustworthy advisors around. So seek out that advice from people such as Ginette and people such as Chris, who've seen it all before. They've seen it all before. Okay. So just to round up, just to probably a couple of minutes, just on what are we seeing at the moment? Okay, what are we seeing in the world as we see, should we call it post-COVID or AC, after COVID? So what are you seeing, Chris? Anything sort of industry-wise that's different from what you've seen before?
Construction industry is normally the number one, if not number two, industry for corporate failure every year on year. And there certainly seems to be a lot of pressure on small builders at the moment. And I remember doing a similar cast like this with Russ Stevens, and he said there's builders that know their numbers and there's builders that don't know their numbers. So the builders that do know their numbers have already assessed their viability, looked at all the unprofitable contracts, got rid of them, focusing on profitable contracts, potentially changing the way they do contracts, which is a cost uplift type approach, or an ability to pass on cost rises to the ultimate customer. But there's also people that are stuck in fixed contracts that can't get out of them, and prices are going up, and the builder just can't complete.
So it's kind of the same, only more so, but also with this price inflation that we've seen over the last couple of years.
Labour shortage as well, materials shortage. So they're being impacted by the supply chain.
And staff shortages, things like that. What do you see?
Particularly, I've got quite a few clients at the moment in hospitality, catering, restaurants, etc. And the similar problems with labour supply, cost of labour, inflation. It's time to put your prices up, but that push-pull experience of not wanting to, etc., is making it very tough for them. So, of course, they fall behind with their PAYG, which is problematic. So, I mean, other than the building and construction, I'd say that's another area, retail and hospitality, that's going to be in for some uncomfortable times ahead.
And this time it's not so much a demand squeeze, as lots of people want to go out for restaurants, there's no one to actually serve them. Well, okay, that's been a fair bit today. I really appreciate both of you coming along today on this video version of the Sounds of the Baskerville. So, Ginette, thank you very much for joining us today. There's Ginette Muller, who's the principal of GM Advisory, and also a member of the solvers.com.au, and also Chris Baskerville, star of the show, The Sounds of the Baskerville, who can be heard on Spotify and iTunes. Managing partner of Jersh Sutherland in Brisbane, and obviously also member of the Insolve panel. Thank you both.
Thanks, James.
Thanks, James.